Hi everyone, my name is Tina Schenk and I'm here to give you part 2 in the MUWE webinar series about copyright for composers. This time we're talking about how to protect your copyright and I hope you can find it useful. I gave a summary of your rights in part 1, so I suggest you check it out. Just a quick recap is that as a composer, you have the right to claim authorship to a piece, and you have the right to decide everything about your piece, including distribution and performances. Your copyright is protected for a minimum of 50 years after your death. This is international law. There are a few exemptions, and I'll list them in part 1. They're very specific, but generally they need to have some sort of public interest behind them. Check out part 1 to get the full list. Now, what can you do to actually protect your rights? First, and most importantly, get a timestamp for your project. That means a DAW project, which has a timestamp already. If you write by hand, either chords or lyrics or notes, just snap a picture of it so that you have it with a timestamp as soon as possible. You can do this throughout the process, it doesn't have to be a finished piece. Or maybe you do an audio recording, whistle into your phone or sing. This will also have a timestamp, so basically anything digital is a good way to fix your creation. Earlier, people used to mail themselves copies and keep the envelope unopened, but you don't have to do that anymore. You also don't have to register your copyright anywhere. It exists the second you started creating the piece. Another thing that you should do is to put a copyright declaration on anything that you distribute. Basically, just the names of everyone involved and who's the composer, performer, etc., etc. An important thing that you should do too is to register with a national PRO or the copyright collective in your country, where you register a piece and get an ISRC code or International Standard Recording Code. This code is used for collection of royalties through radio or streaming, TV, etc., etc., even on YouTube. Just know that membership may be subject to qualification. For instance, your music may have to be published, which is the case here in Norway. Also note that it can be different PROs for instance, compositions and for performances, which is the case here where I live. You can find a list of copyright collection agencies here in this Wikipedia link, and I'll put that in the description as well. Now, some distributors ask that you're not affiliated with a PRO altogether. This is very sketchy because it should be plenty for you to just have to declare to your PRO that a piece should be exempt of royalty collection. So really, they should only either ask that the singular piece isn't registered with a PRO, or they shouldn't be asking it at all, in my opinion, the latter. Because if they ask that you as an individual are not affiliated with a PRO, it takes away your potential to monetize on other pieces of music that you didn't register with that distributor. One of these distributors is Epidemic Sound, and I'm sure there are plenty others, so just be aware that this is a structure that exists, and you should definitely read the terms very carefully before you distribute with someone. Also, as I mentioned, you can be in a PRO and distribute music royalty-free, which basically you register a piece, you get an ISRC code, and then you declare to the PRO that you want the piece to not have royalty collection attached to it. This is great if you want to sell a piece of music, for instance, for a game or a film, and you just want to do like a lump sum transaction. Things to be wary about is Creative Commons licensing, which is very common. I'm sure you've heard of it. Make sure to choose the right one if you want to use one, because the Creative Commons licenses are made for users of a piece, not the creators. And if you license a piece under a CC license, it may prevent you from monetizing off that piece later. So there are certain licenses where you can license a piece for use privately but not commercially, and I suggest if you are to choose one, make sure to select, first of all, select very carefully, and I would just not go with a commercial license at all through CC, because you would want to make money off that piece later. Another thing to be careful about is how you distribute your work. Some platforms like SoundCloud have an option of direct download, and don't enable this until you're absolutely sure that you have put a copyright declaration or check the box that says all rights reserved or something similar. Because basically when people can download your music, I'm sure you know, they can just plain old steal it and use it for whatever, although they don't have the license. So this is one way to control your music, and the pathways it take is to not enable direct download at all. Another thing to be wary about is this new big trend of the blockchain or other open source platforms where anyone can just modify the platform. Blockchain is created, as I understand it, to exist outside of any jurisdiction, so it's really hard to police copyright in a blockchain situation. And for instance, Audius has been discussed to be a copyright nightmare, and SoundCloud is also soon going blockchain. Basically, what it can do, although it won't distribute your music freely, what it can do is modify the platform, so the criteria for distribution will be different and you may not get a notification on that. So basically it removes your music one step further away from your control. So be cautious about this. If you do find out that there is copyright infringement going on for your piece, then here is a little action plan for you. First of all, ask to have the item taken down if that's what you want, and you can take legal action to have this done. There should be some kind of interest organisation somehow, maybe the Copyright Collective or other interest organisations for either copyright or musicians, or you can involve a lawyer, make them send an angry letter. Then I suggest you send an invoice for the usage that someone already got off your illegal use of the piece. And then you consider if you will grant permission for future use of the item and send an invoice for that too. And if you don't want to grant permission, raise hell to have it taken down, because you have the rights on your side as a copyright holder. Just be aware of that, even if someone is difficult about taking stuff down. Which leads me to YouTube, because YouTube proves to be notoriously difficult to have stuff taken down of. It does have some structures in place for copyright protection, but they're not very good, and they rely entirely on the fact that music has been published. So if you have unpublished music that you discover on YouTube, then you still have copyright to that, and you still have protection by international law, but YouTube probably won't do much to help you. As long as you have a timestamp, you can always object to the use of your music, even on YouTube, and involve a lawyer or interest organisation if they're being difficult. As long as you have a timestamp for the point of origin of the piece, you should be able to have stuff taken down, or at least recover your copyright. And if you discover a cover of your unpublished music, notify whoever posted it that the use is unlicensed and illegal, and send them an invoice. And then consider if you want to ask them to take it down. Now, in general, these rules may seem a little outdated, but this is because the internet, of course, evolves really quickly, whereas law needs democratic processing, so it takes years to form. But it has so many layers of quality control that the internet in general doesn't have. It also has public will and lots of research going into it, so it should be a positive thing that these rules are strict and in place to protect you. And something is not legal just because everyone else is doing it, like making covers that are, I don't know how many millions of covers there are on YouTube, but it is illegal if you don't have a license or a permission. Even making the Super Mario Brothers cover on piano is illegal, even if you don't make any money off it. So, if you discover someone is using it and everyone else is using it too, maybe your piece goes viral but you were never notified or asked in the first place, then it's still within your copyright. You can have it taken down, you can send a massive invoice, do that. But this is what I'm going to be talking about the next time, how you would go about other people's music, like sampling, making covers, and in general, where the limit goes for sources of inspiration. In the meantime, find me on Tina Linen on Twitter, and check out the Music Weeklies challenge, where you can find us at Music Weeklies on Twitter, on SoundCloud, and here on YouTube. And we have a website, musicweeklieschallenge.com. And I'll see you next time.